I'm Jessica Ness from the Department of Political Science, Salesian College, Sonada. Today, we will be discussing about public interest litigation, popularly known as PIL. Now, public interest litigation is a relatively new branch of law that is being practiced in India. The main objective of any judiciary system is to dispense justice to the people, to make the judicial system active, efficient, less costly, and as far as possible, simple. PIL is also described as the new legal horizon. PIL is being initiated and popularized by eminent person Justice P.N. Bhagwati. Public interest litigation can also be described as a legal system in which the court of law can be initiated and enforced action for securing any significant public or general interest which is adversely affected or is likely to be so by the action of any agency, public or private. In one of the judgments, Supreme Court has also described public interest litigation as a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of the community has pecuniary or some other interest to which its legal rights or liabilities are affected. Under this system, any citizen or a group of citizens or an organization can also approach in writing, even on a postcard, or to the High Court or to any other court, bringing to notice the need for protection of the public interest via particular law or any policy or any action of the government. The judicial judges can initiate these cases in case they find it is to be justified in public interest. Now, there are some features of PIL. And the main some features of PIL is that the system is dispensing justice without usual requirement of the person affected alone seeking redress from a court of law. The legal and the social activists can also move to court for securing relief to the poor and deprived section of the society, that is, for securing public interest. Even the judges can do so through suo act after reading a newspaper, report, or any other means. PIL is a combination of formalization that stand attached with the judicial system, with some information the characterize of a tribunal or a departmental system. PIL avoids the formal approach to the court. Its initialization does not require a formal petition, a prescription format, and a manner to be presented in court. Any person or agency seeking justice can write even a postcard to the court. In case the court considers it's a fit case, can initiate action. There are reliefs in case of PIL cases. In PIL cases, the court can grant relief to the aggrieved group or the person. The nature of relief that can be given under the system is also innovative in nature. For example, the court can grant compensation to the sufferer in the case of murder, rape, or any injury. Another significant feature is that while the fundamental rights can be enforced only against the state, the relief provided by the court in public interest litigation cases tend to embrace the bodies as well. It is also held by some experts that PIL can be used by consumers and other such forums for securing the desired relief in a simple and efficient manner. Going to the next point is, when we get benefits, people tend to misuse PIL. So yes, PIL has been misused previously also. I can give you some examples. Examples like Mrs. Ramaswamy, whose husband Mr. Ramaswamy, a judge in the Supreme Court, was facing a corruption charge. Mrs. Ramaswamy moved to the Supreme Court a PIL petition to enforce her rights. In this case, honorable members of the Supreme Court ruled that when the grieved person himself did not claim any relief, no relief can be given on behalf of him. This shows that people have tried to hack the PIL system for their private gain. In another case, we can see another case like Mr. H. Chaudhary, an advocate practicing in Delhi, filed an appeal to the to a special court for quashing the FIR and withdrawing the letter of rogatory, which the government had issued in the Bosfor case. Three political parties, the Janata Dal, CPM, and the INC, that is the Indian National Congress, the Socialist Party, were also figured in the case. When the special court did not accept the plea, they moved to the High Court and then to the Supreme Court as a PIL plea. All the courts turned down the petition on the ground that only a person or a group or a body acting as a bona fide can have sufficient interest in PIL could approach the court for wiping out the suffering of the poor and the needy. PIL hence could not be ruled in these cases. And we can further see that the Supreme Court held Mr. Chaudhary very concerned with a personal and private interest of the accused of the Bosfor case. Hence, we can see in different mediums, PIL was not only used to benefit a person privately but also politically. Now, on the view of the critics of PIL, the critics of PIL hold that without guideline, this system cannot overstretch and be used by the courts. These can overstep the limit. Another point of criticism which merits attention is that even after securing relief under this system, the sufferers really fail to gain much of the poor and the inefficient follow-up action. For example, in the case of a bonded labor, they got some relief, but once in the realm of freedom, they face starvation and death. This forced them to return to bonded labor in the name of a free contract or even without a contract. Neither the court nor the government could provide them with any follow-up relief. And the last point is the justification of PIL. It must be admitted, however, that because of being a comparatively new system, PIL is yet to become fully useful. It is indeed a beneficial system and has several committed and active supporters. More and more PIL cases are being filed in the court, and more people are getting benefited from this system. PIL has been successfully used by several socialist activists in a case solving Asian laborers, the inmates of women's home in Agra, the bonded laborers in various parts of the country. PIL offers increased opportunities for the people to secure the needed relief against acts of commissions and omission on the part of the government and any decision makers. It constitutes a useful and a needed addition in the Indian judicial system. With that, we conclude our lesson by saying that since 1994, the International Institute of Public Interest Litigation has been in work in India. It enjoys the full support and backing of the legal luminaries as well as some judges of the Indian Supreme Court and the High Court. This institute is a platform for popularization in PIL. PIL has now become an active and important part of the process of judicial activism in India. While the power of granting the fundamental rights through dependence upon Article 32 and 226 of the Constitution, as well by the use of the system of judicial review, constitute a strong judicial weapon in the armory of judicial system. The system of PIL constitutes an international leverage of the judiciary for ensuring speedy relief to the poor and the deprived, and in a process to discharge its social responsibilities through judicial activism. Thank you.